Dear Professor and classmates, my name is CHAO. My topic today is the settlement of disputes on the law of the sea. Contents. First, the principle and the general provisions. Second, compulsory procedures. Third, limitations and exceptions. Let's see. Subject and object. Subject. A state party, of course, is the subject of the dispute settlement system. But if an entity other than a state part is a party to such a dispute, this section can also apply according to Article 285. Object is any dispute concerning the interpretation or application of this convention. Before introducing the specific content of the dispute settlement system, we should first know its principle. There are two important principles. First one, the principle of free choice of peaceful means. It's a manifestation of the principle of equality of state. Regardless of difference in terms of geographical size, population, military power, economical strength, and so on, states are free from any pressure from other states in choosing the method. Second one, respects the agreement reached by the parties to the dispute regarding the settlement of the dispute. It is said in Article 282, obligations under general, regional, or bilateral agreements. Now we can see the general provisions of the settlement of dispute mechanism. Let's have an imagination. There are two countries, A and B. They have a dispute. First, under Section 1 in Part 15 of the Laws Convention, parties shall solve their dispute by any peaceful means of their own choice. Any peaceful means. They can include exchange views, negotiation, or other peaceful means indicated in Article 33. Paragraph 1 of the Charter. Let's have a look. The countries can seek a solution by negotiation, inquiry, mediation, conciliation, arbitration, judicial settlement, resort to regional agencies or arrangements or other peaceful means of their own choice. But after all this, no settlements has been reached. So what can we do? We can apply the compulsory procedure, leading to a binding referee in accordance with Section 2 of Part 15 of the Convention. Now the question is how to use the compulsory procedures. There are three prerequisites. No settlement has been reached by recourse to Section 1, exhaustion of local remedies, at the request of any party to the dispute. Besides, countries should know the refuge by compulsory procedures is final and binding, but only between the parties and in respect of the particular dispute. That is to say, the refuge has the binding force to country A and country B, but it has no binding force to country C. And when a new dispute happens, the refuge has also no binding force. At last, country A and country B have four choices of procedure. When seeing writing notifying or acceding to this convention or at any time thereafter, a state shall be free to choose, by means of a written declaration, one or more of the following meanings: A. The International Tribunal, B. The International Court of Justice, C. An arbitrary tribunal, D. A special arbitrary tribunal. That is to say, country A could choose the International Tribunal. Country B could choose maybe an arbitrary tribunal. Then they may reach an agreement. First choose the International Tribunal, but if finally they couldn't reach that agreement, what would happen? Article 287, paragraph 3 and 5 tell us the answer. If a party to a dispute is not covered by a declaration in force, a state party shall be deemed to have accepted arbitration in accordance with Annex 7. If the parties to a dispute have not accepted the same procedure for the settlement of the dispute, it may be submitted only to arbitration in accordance with Annex 7, unless the party otherwise agree. So, after the compulsory procedure, the dispute between country A and country B is finally solved. But there are some limitations and exceptions to the compulsory procedure. First, conciliation. These three situations cannot be used the compulsory procedure, but can only choose conciliation. This part will be specifically explained by my friends, so we just have a look. A dispute about the marine scientific research, the dispute about the living resources, the dispute about the sea boundary delimitation or historical base or titles. Now, Article 298 tells the three situations that when this happens, a state may at any time declare in writing that it does not accept any one or more of the procedures provided for in Section 2 with respect to one in Section 2. Let's see. A. Disputes concerning the interpretation or application of Articles 1574 and 83 relating to sea boundary delimitations, all those involving historical base or titles. B. Disputes concerning military activities. C. Disputes in respect of which the Security Council of the United Nations is exercising the functions assigned to it by the Charter of the United Nations. This means the state has the right of the free choice. Just like we said in the beginning, the principle of free choice. It is all for the respect the sovereignty of the country in dispute, the jurisdiction of international organizations. This is a summary of the settlement of the dispute mechanism in the Laos Convention made by one judge of the International Court of Justice. The first rule is the sixth dispute topic of Laos Convention. The second rule is the specific subject to the compulsory settlement procedures. The third rule is the others. We can use this summary to review today's learning about limitation and exceptions. Before the conclusion, let's do a review about the settlement of dispute mechanism. First, use Section 1's peaceful meanings. It includes exchange views, negotiation, or others. If no settlement has been reached, we can choose the compulsory procedure. The referee is binding and final, but we should know there are some limitations and exceptions. So at last, we all know the settlement of dispute mechanism in the Laws Convention is recognized as being both simple and complex. It insists on the principle that the parties to a dispute freely choose the method and allows the parties to choose any peaceful method to resolve the dispute. For disputes that cannot be resolved by the parties choose the dispute compulsory procedures should apply. Thanks for listening.